A manager is dismissed after raising concerns about unfair treatment at work. They feel certain they have a strong case, but when they start looking into it properly, the question becomes more complicated. Is it actually strong enough to win? Because in employment law, there is often a big difference between what feels unfair and what is legally actionable. And understanding that difference early can change everything. So let's talk honestly about what makes a case strong and what can weaken it. First, a strong case usually has clear evidence. Not just a feeling that something went wrong, but documents, emails, messages, or witness accounts that support what happened. We recently advised an employee who believed they had been unfairly dismissed after years of good performance. The problem was that most of the key conversations had taken place verbally, with very little written record. That made the case harder to prove, even though the employee genuinely felt wronged. Second, timing matters. If there are long delays between events and raising concerns, employers often argue that issues were not serious at the time. Early action, whether that is raising a grievance or documenting concerns, can significantly strengthen a position later. Third, consistency is important. If your account of events changes over time, it can weaken credibility. But if your version of events remains consistent and is supported by records, that is much more persuasive. Now let's talk about something many people misunderstand. Not every unfair situation is automatically a legal claim. Employment law is very specific. For example, unfair dismissal usually requires at least 2 years' service, unless discrimination or certain other exceptions apply. Discrimination claims do not require length of service, but you still need evidence showing less favorable treatment linked to a protected characteristic. Whistleblowing claims require evidence that concerns were raised in a protected way and that detriment followed as a result. So the legal category of your case matters just as much as what happened. Another key factor is process. Even if an employer has a reason for dismissal or disciplinary action, tribunals often focus heavily on whether they followed a fair process. We have seen cases where the underlying reason for dismissal might have been potentially valid, but the procedure was rushed, inconsistent, or poorly documented. That alone can make a case stronger for the employee. Now let's be clear. A strong case does not mean a guaranteed win, and a weaker case does not mean you have no options. Employment law outcomes depend on evidence, credibility, the legal framework, and how the situation is presented. That is why early assessment is so important. So what should you do if you are wondering whether your case is strong enough? First, gather as much documentation as possible. Emails, messages, and notes matter more than most people realize. Second, write down a clear timeline of events while everything is still fresh. And third, get early legal advice before making major decisions like resigning or signing agreements. At Blackstone Solicitors, based in England, we help employees assess the strength of their case and understand their legal position in unfair dismissal, discrimination, and workplace disputes. Because in employment law, strength is not just about what happened, it is about what you can prove.